The Attorney General guidelines, oddly enough, originate probably back in 2004 when we sued the California Highway Patrol over its policy. One of the worst policies, if not the worst policy in the state, in the area of medical marijuana, was California Highway Patrol's policy of seizing marijuana in all cases in which it was discovered. So back in 2004, the CHP policy would be, if an officer confronted someone with even a very small amount of marijuana claiming a medical use of that marijuana, they would seize the marijuana, they would charge the person with marijuana possession, and then they would obnoxiously inform you of your right to file a motion for return of property in court. At ASA, we thought that was blatantly unconstitutional, and so we sued the California Highway Patrol. The California Highway Patrol soon thereafter changed their policy to one that was very favorable. It actually instructs its officers not to seize the marijuana and to let people go if they present facially valid documentation of their status as a medical marijuana patient. And it's that CHP policy which we later see codified in the Attorney General guidelines. The stranger part about that case was by suing the CHP, we actually started to develop a relationship, a positive relationship with the Attorney General. Although the Attorney General in that case was our opposing counsel, they acted reasonably, we acted reasonably, and I think for once law enforcement could actually see that medical marijuana advocates could act in a reasonable fashion to try to make all of this work that's acceptable to both law enforcement and to patients. Unfortunately, the CHP policy was not followed in many jurisdictions. And for instance, the city of Garden Grove. In the city of Garden Grove, a gentleman named Felix Cobb was driving his car. He ran a stop sign, was pulled over. A cop asked him, "Do you have any drugs or alcohol in the car?" He says, "Yes, I do. I'm a medical marijuana patient." He takes out his 3/8 of an ounce of marijuana. The cop seizes the marijuana, cites him for running the stop sign, cites him for marijuana possession, and so Mr. Cobb has to appear in court. He goes to court, pleads guilty to traffic violation, and the prosecutor then dismisses the marijuana charge. And Mr. Cobb says, "Yeah, and I'd also like my marijuana back." So the court holds a hearing, actually 2 hearings, and at the conclusion of which the court orders the return of that marijuana to Mr. Cobb.
Yeah.
Not so good, as many of you probably know, the police are above the law. And of course, they don't actually have to abide a court's order. So when Mr. Cobb went to the police property room in Garden Grove to try to get his marijuana back, they refused to give it back to him despite the court order, which is when Mr. Cobb contacted us. And I wrote a not-so-friendly letter to the city attorney for Garden Grove, attaching a copy of the court order and asking why they're not abiding the court's order. This prompted the city of Garden Grove to appeal the court's decision, and it turned into a somewhat crazy case called City of Garden Grove versus Superior Court. It sounds like a few of you have heard of this case. And hopefully you haven't, and I'll explain how this actually plays into the AG guidelines, although I will use any subject as an excuse to talk about the City of Garden Grove case. After several years, what happens is through our relationship with the Attorney General, actually dealing with the settlement in the CHP case, I made them aware of the Garden Grove case, which prompted the Attorney General to file an amicus brief on our side. And this, of course, is bringing some great weight to our side of the fence. This, of course, prompted every law enforcement agency in the state, the California Sheriff's Association, the California Peace Officers Association, the California Police Chiefs Association, as well as the California District Attorneys Association, to file an amicus brief against this. So you have this bizarre situation with the Attorney General on one side and all of law enforcement on the other side. After several more months of waiting, the case was finally heard in a unanimous 41-page published opinion. We won the Garden Grove case, making clear that the cops perhaps as importantly, the court did 2 things. One, the court said it's the responsibility of local law enforcement to enforce state law, not federal law. And the other thing it did is it made clear that medical marijuana patients are not criminal defendants and ought not to be treated as criminals by the police. This angered law enforcement, but it prompted law enforcement to actually go to the Attorney General and ask the Attorney General to issue some wide-ranging guidelines. We have been asking the Attorney General to do this for years, but they're a little bit more persuaded than law enforcement does. So they decided to come up with guidelines. And out of the blue, I get a call from one of the deputy attorney generals who's primarily responsible for drafting the guidelines and saying they'd like us to see the guidelines, give some inputs. They want to get input from both law enforcement and from advocates. But the price of poker was we couldn't let anyone know about our involvement in this until the guidelines were published. And I know many people aren't particularly pleased with us for doing that. I can tell you from seeing the first draft of those guidelines to what ultimately came out of those guidelines, they would have been far, far worse had we not been involved in drafting them. We're very pleased with the final product, and you'll just have to take my word for it. No one in this room would have been pleased with the initial product. Aside from doing some of the mundane things, it codifies existing law, it just codifies existing decisions by the Board of Equalization about sales tax, talks about the medical board briefly. The guidelines do four major things. I would say for better, some people might say for worse. The first thing it does is it codifies the seizure policy that originally started with CHP and also comes from the Garden Grove policy, which instructs police if they confront a medical marijuana patient with facially valid documentation, you don't have to have the state-issued ID, even a doctor's recommendation, they are not to seize your marijuana if you come below the threshold quantities of SB 420. So that's if you have less than 6 mature plants or 12 immature plants and 8 ounces of dried marijuana. If they come across that, you show them facially valid documentation. They're supposed to let you go, not take your medicine. And this is a great improvement over the policies that we had seen in the past. On the other hand, they say if you're above those quantities, then they can take your marijuana. Needless to say, we objected to this provision. I know a lot of people are not happy with treating SB 420 as providing limits. We don't think they should be treated as limits either. But by and large, it's our opinion that the policy will help thousands of medical marijuana patients. Unfortunately, it may harm some, but ultimately, it will help limit harms. The second major important piece of the Attorney General guidelines is the Attorney General gives its opinion to law enforcement that where someone is complying with state law regarding medical marijuana, local law enforcement are not to use federal law as a reason to arrest or seize the marijuana from patients. And this is very important because we've heard a lot of local law enforcement who have a predilection for federal law, who wish to use that, to use federal law as an excuse to harass medical marijuana patients. And the Attorney General guidelines tells them they're not supposed to do that. The third major provision, which comes from both the first two, is it explicitly tells law enforcement that they should return marijuana where it's been improperly seized in the first place. This is basically the theme of the Garden Grove case, but it's nice to see now that the state's highest law enforcement administration is basically telling law enforcement not to seize the marijuana to begin with, if they do, to give it back, and if there's a court order, to abide that court order. Not that they always do so. We actually still see some local police property rooms refuse to give back marijuana even when someone has that valid court order. And the last one, and this is a big one, deals with collectives and cooperatives. And I know some people aren't particularly happy with some of the limitations that are placed on collectives and cooperatives, most notably that they're to operate on a nonprofit basis, that they're supposed to keep records, I think everyone is happy with the fact they have to verify membership, but there had never been, dispensing collectives have always been a gray area under the law. And they've been tolerated, and people think they're legal, but there's never really been any official legal recognition of that. And for the first time, the Attorney General guidelines actually state that storefront dispensaries that sell marijuana on a retail basis may be legal under California law, so long as they otherwise operate in compliance with these guidelines. So in other words, for the first time, you have a formal legal recognition of medical marijuana collectives under California law by the Attorney General. So overall, we'll have to see where these guidelines leave us. We think ultimately it will lead to the result that we're seeking, and that's to cause law enforcement to leave patients alone. Thanks.